Okay, next we're going to talk about the Supreme Court and how it can be checked, as in checked and balance, checks and balances, what can have an effect on the court in terms of its behavior. Every branch of government, of course, has a means by which it can be stopped by the other branch or checked by the other branch. So let's talk about the courts themselves and in particular the Supreme Court. Okay, so in fact, that over the decades and maybe over well over 100 years, the Supreme Court has been known for issuing some fairly controversial decisions. And let's be honest, there were eras in which the Supreme Court membership, many of them or most of them were racist, and so many of their decisions that came out were a product of their racism. Bad decisions. For example, I mentioned Plessy versus Ferguson in the last lecture of 1896, which basically legitimized Jim Crow in the South, separate but equal, that doctrine of separate of equal. Well, that was created by a pretty racist Supreme Court. And so the big question is, well, what happens with bad decisions? How can the court be stopped, if at all? And we've kind of alluded to that in the last lecture as well, related to precedent and overturning precedent. But let's move forward and see what we have here. So we know that Congress, one major check on the court system, the federal court system, is that Congress has that, believe it or not. Congress, in fact, can pass laws that undermine or go around certain Supreme Court decisions that are determined to be not very well serving for the community as a whole. So Congress can make laws that undermine a Supreme Court decision. For example, we mentioned the US v. Lopez case. This is the case related to a young man who brought a gun to school, and he was arrested and charged under the federal Gun-Free Zones Act. The Supreme Court actually determined that law to be unconstitutional because a major part of that law was legitimized through the Commerce Clause of all things. And so the Supreme Court at that time basically made the law unconstitutional, the Gun-Free Zones Act law under the Commerce Clause. And so what did Congress do? Well, Congress thought that the law was actually pretty good, that a person bringing a gun onto a school campus should be held for a felony. And so what Congress did was retailor the law on the Gun-Free Zones Act, and they pulled out the Commerce Clause that the Supreme Court found to be objectionable and unconstitutional, and they just passed a new law taking out the Commerce Clause. So this is an example of Congress working around a Supreme Court decision that they didn't really agree with. And so, of course, the major way by which Congress can move around a Supreme Court decision that, remember, the Supreme Court has judicial review determining whether acts are constitutional or not, meaning laws that are passed are unconstitutional. Well, the very act of Congress creating, believe it or not, a constitutional amendment, if they create, let's say, a flag burning constitutional amendment, meaning that no one in this country can burn a flag without some sort of federal penalty, if that becomes a constitutional amendment, then there's nothing the Supreme Court can do to overturn that sort of law. The Supreme Court might say, well, burning the flag, that's First Amendment symbolic speech rights. The Supreme Court might disagree with Congress's constitutional amendment. But this is one example of where a constitutional amendment is stronger than any Supreme Court decision because, in fact, it is constitutional when Congress passes, along with the states, a constitutional amendment. So constitutional amendments serve as a powerful tool for the legislative branch to counter controversial court decisions and to redefine constitutional interpretations. Another thing that Congress can do surprisingly is they can determine the Supreme Court's jurisdiction. So what does jurisdiction mean? It means that basically it means a zone of area in which the court is responsible for. So types of cases that the Supreme Court takes on mainly are appellate cases or appeals cases. They also handle not just appellate, but they do have primary responsibility over certain cases. But it's very possible that Congress can tell the Supreme Court, this is constitutional, by the way, on cases that they do not have permission essentially to oversee. One example is the Guantanamo cases that occurred back during the Gulf War and the war on terrorism, where a lot of enemy combatants during the war in Afghanistan were taken straight to Guantanamo Bay, Cuba. And so, in that regard, being in Guantanamo Bay, Cuba, they didn't have any real rights because they were international waters. And so, the Supreme Court was given by an attorney for one of the folks that were being held without charge, by the way, and without any idea when they might be released. They lawyered up and they sent this case all the way to the Supreme Court. And Congress actually attempted to block the Supreme Court from overseeing this particular case. They tried to assert in fact, their ability to deny the Supreme Court the right to hear a particular type of case. Ultimately, the Supreme Court did hear the case, but that's not to say that Congress doesn't have the right to actually determine the types of cases that the Supreme Court takes on. This is a pretty major check and balance on the Supreme Court's authority. What about the executive branch? Well, one way that the executive branch might have an effect on the U.S. Supreme Court, and I've mentioned this already, but when you have judicial retirements, and maybe you have 2 or 3 judicial retirements and for one presidency, and this has happened, I mentioned during Donald Trump's term, and it also happened with Richard Nixon as well. I believe there were nearly 3 or 4 retirements when Richard Nixon was president. And so if you have more of a liberal court and you have 3 judges retire, a Republican conservative president can then turn around and select conservative judges to replace the ones that are retiring. And if you have a Senate that is Republican dominated, they're going to go ahead and approve those nominations. And so a president and through retirements can change the whole complexion of the court in terms of it being super conservative, super liberal, or maybe more on the moderate side. So again, a new court with a new completely point of view, they can overturn cases that they deem that were, like liberal. If you have now a new conservative court, they might start attacking former decisions that were considered liberal decisions. And Roe v. Wade, as I've mentioned before, is a decision that this new conservative court that was changed by Donald Trump through his nominations, they literally overturned 50 years of precedent in Roe v. Wade, where women had the right to have an abortion. And so that's an example of a check and balance on the court from the executive branch by literally changing the whole type of court that is in place. And now we see different decisions that were formerly almost 180 degrees the opposite of what the former court held before. And so this is an effect that the executive branch has on the judiciary. Also, here's something as well. So the Supreme Court can issue any decisions that it wants, but as has been stated, the Supreme Court has neither the purse nor the sword. In one of the Federalist Papers, that's a famous quote. And what that means is that, okay, the Supreme Court can issue a decision, but it's really up to the executive branch and the executive agencies to carry out a Supreme Court decision. So really, a Supreme Court decision, believe it or not, can be ignored. There have been many instances of states ignoring judicial decisions. For example, I mentioned Brown v. Board. It took probably about 20 years before desegregation really occurred in the South. Many Southern states dragged their feet on enforcing integration into the schools. And so that's a big example of how states can ignore Supreme Court decisions. And in some cases, presidents can too. Even after freeing of the slaves, the 13th and 14th Amendments. The 14th Amendment gave all sorts of rights and equal protection to former slaves. Well, we know that all of that equal protection was denied for decades in the Deep South, even though, again, right after the Civil War, the Supreme Court issued the 14th Amendment. So again, Andrew Jackson famously said, well, John Marshall can issue a decision, but let's see him try to carry out that decision. And this was related to the removal of Cherokee Indians from Georgia, which was ruled unconstitutional, but Andrew Jackson just ignored that ruling and said, he can do it more or less. So it's really up to the will of both the executive branch and even the legislative branch, and certainly the states, as to whether they carry out Supreme Court decisions. Finally, concluding, the other branches of government have multiple means to check the Supreme Court's decisions. Congress can modify laws, as mentioned. They can propose constitutional amendments that impact the court's jurisdiction, through legislation. And of course, the president can influence the court's direction through their own judicial appointments, and in some instances, choosing not to enforce certain decisions. So these are all types of checks and balances. Believe it or not, the founders had this in mind. This is so, to counteract the claim by Brutus I that, the courts could run away and act tyrannically. Well, there are plenty of checks and balances to keep the courts in their proper place, let's just say.